The multinational oil and gas company Shell has been ordered to halt its seismic survey along the Wild Coast. The High Court in Makhanda issued an interdict against the proceedings this morning. The operations kick-started earlier this month with environmental organizations arguing that the survey will cause harm to the marine environment as well as communities in the surrounding areas. Shell and Mineral Resources and Energy Minister Gwede Mantashe were ordered to pay the legal costs of the application. Now, joining us for some legal analysis on this development is Johan Lorenz, Associate at Richard Spoor Inc Attorneys. Johan, a very good morning to you. Good afternoon to you, pardon me. Thanks for joining us. What's your immediate reaction to this court outcome?
Thanks, Info, and thanks to your viewers. A very good afternoon indeed for certainly our clients and our team. The late Archbishop said, do you a little bit of good where you are. It's those little bits of good put together that overwhelm the world. And I think our reaction, our clients' reactions, our clients are all communities along the Wild Coast who were entirely neglected in the application for exploration rights to blast their seas every 10 seconds at 250 decibels for 5 months. They're entirely neglected. And now today, there's a lot of joy, perhaps a little bit of schadenfreude at the fact that there are consequences for ignoring the rights of communities. So there's a lot of joy as well as a lot of conviction from our clients. But this is one small step in the struggle for community self-determination, for communities to develop on their own terms with the state's support, and against climate change.
I know that there are also two legal matters that are at play here. Talk us through them.
Right. So, as is set out in the court papers and in the judgment, there was a previous application that probably the interdict should have been granted, brought by various NGOs. Those papers came together very quickly and were on different grounds. They sought to challenge the legality of the Shell's permit, Shell's exploration rights, whereas our clients were communities who had no knowledge prior to late October 2021 that the seas were about to be blasted. So it took much longer to put their court papers together than it did for the other applicants in the other case, and they had a different ground. Their ground was that, yes, Shell may well have complied with the minerals legislation, but despite that, Shell also had to comply with the National Environmental Management Act, because that gives effect to their constitutional right to conserve the environment in a sustainable way, in a way that supports their livelihood. And Shell said, not a chance, they don't need to comply with that. And so there's a very crisp legal issue here. And it looks like our clients, today's order is just a temporary order pending a final outcome. That final outcome should come perhaps in January or February. But our clients are certainly feeling very confident of their merit.
In the clients feeling confident, what were some of the legal matters and perhaps discussions that were put forward in arguing for this matter?
Right. So the central argument was one of consultation, that at best, the company that came before Shell and that Shell bought its rights from may have spoken to a king or queen that ruled over them. At best, even that was disputed. But there was no effort at all to engage with the communities about the impacts of this seismic blasting will have. And they said that was important because they sustain themselves through the fisheries, that there's contested evidence that some of the world's leading experts suggest will be very significant damages coming out of these activities for the fisheries. And they also said there are spiritual and cultural impacts that they fear from the fact that every 10 seconds there will be a blast that can be heard as far as 100 kilometers away through the sea that will affect their ancestors who live in the sea and who provide healing powers to them. And so the main case was about what would it take to have a dignified consultation process with our clients. And I appreciate that some people may be concerned that this sounds like too high a burden. What a good consultation process will allow for is to hear all the voices and then for the government to make an informed decision based on a full array of voices and interests. But just to speak to a king at best and to ignore all the traditional communities along the entire stretch of the Wild Coast simply seems to be plainly unlawful from today's judgment.
We know that Shell had warned during legal arguments that if the interim interdict was granted, the company might have to walk away from this entire operation and lose out on millions of rands. I mean, how does that now affect the case moving forward? And also considering the role that government played in perhaps coming to the defense of Shell, how does that bode with the people?
So I think with the first point first, I think things are often said in litigation that aren't always sincerely meant. Sorry, I have a helicopter flying over me. I hope that's not too bad. Things are often said in litigation to win that aren't meant, but sometimes they are. So I think now we'll see whether Shell was serious, that there is a risk that if they're told to follow the law, they will pull their investments, in which case our clients would say good riddance. But perhaps now they will follow the law, and we'll see whether their investments succeed. I think the role of government is a particularly troubling one. You know, our clients are Wild Coast communities who fought in the Amampondo revolt against apartheid, fought against colonialism, and were involved in the liberation struggle. They expected much more from the ANC government, the liberation government, that they voted for at 97% in 1994. And are grievously disappointed that their impression is that government chooses the side of a multinational corporation that was involved that was connected to the apartheid government over themselves. And I think they're strengthened in that perception by the fact that Minister Mantashe suggested that their opposition was constituted support of apartheid and colonialism of a special type. So for the state to play that role, I think there's two interesting points. One is that is incredibly disappointing for indigenous people who expected more from their government. Two, I think it's really important that the state reflects on if they let companies get away with breaking the law, perhaps that doesn't help investment in the way they suspect. Because to the extent that there are massive investment losses from Shell being forced to comply with the law before conducting the seismic survey, that is on the head of the state that didn't make them follow the law in the first place. That's not on the head of that's not the fault of communities who asked for the bare minimum. And so I hope there's reflection at the Department of Mineral Resources from Comrade Gwede Mantashe and others on how to respect communities, but also how to seriously take investments, how to seriously support investments by encouraging companies to follow the law before their unlawful conduct hurts them badly.
Absolutely. Thank you so much for weighing in on that discussion from Richard Spoor Inc Attorneys, an associate there, Johan Lorenz.